Greetings, universe. We are here with the APA 2018 Counter Conference. I am joined today by Harvard Law School graduate Jim Gottstein, graduated from Harvard Law and then was involuntarily hospitalized twice in the 1980s due to mania. Since then, Jim has represented people diagnosed with mental illness, such as in the Alaska Mental Health Trust lands litigation, which resulted in a settlement valued at over $1 billion. Jim then co-founded the organization PsychRights in 2002 and has won 5 Alaska Supreme Court cases surrounding Alaska's involuntary commitment and forced drugging practices. Jim has also won a United States Court of Appeals decision stating that psychiatrists who write psychotropic drug prescriptions to children that are reimbursed through Medicaid that are not for a medically accepted indication are committing Medicaid fraud. Thanks for joining me today, Jim.
You bet. Thanks for having me.
So then let's start at the beginning. Why did you start working in the space of human rights and mental health? What first triggered this and got you started?
Well, it was my unexpected involvement with the mental health system. I was on track to just become a basic business lawyer when I had my first manic episode, and that kind of changed the trajectory of my life.
Sure. And then let's dive into involuntary treatment. So a lot of people don't even know what involuntary treatment is. So can you tell me a little bit about the different types of involuntary treatment that are out there, and then we'll kind of talk about how one lands in them?
Yeah, I mean, I really even don't like to call it treatment, but basically, you could say there are 2 or 3 basic types of involuntary psychiatry. The first is involuntary commitment, which is really psychiatric imprisonment. And the legal premise for that is that someone is mentally ill and a danger to self or others. And it has to be a pretty serious danger, and there needs to be some immediacy to it. How's that? Can you hear the phone ringing? Not really. It's not.
Yeah, I can hear it, but it's not super distracting.
Sorry about that. So one of the things I say is that no more than 10% of the people that get involuntarily committed actually meet commitment criteria. Because for one thing, they have to prove it by what's called clear and convincing evidence, which means that you have to have a firm conviction that it's true. So that's more than the normal civil standard in a normal like contract case or personal injury case, which is preponderance of the evidence, which is just that you tilt the scales, and if one is over 50%, then that's a preponderance of the evidence. In contrast to that is the criminal standard beyond a reasonable doubt, which is much more, being much more positive about it than clear and convincing. And interestingly, the U.S. Supreme Court, when it was deciding this case, basically said, well, we can't say beyond a reasonable doubt because psychiatry is so imprecise that you can never get that much because psychiatry isn't good enough at predicting that. Well, studies have actually shown that psychiatrists grossly overstate people's dangerousness, and then oftentimes miss people. I mean, we see that all the time where they miss people. So people are getting committed when they really don't meet the commitment criteria. And that's, I think, like I said, only maybe 10% actually meet the commitment criteria. The other main forced psychiatry is forced drugging or forced electroshock, or involuntary, but let's be, again, not use a euphemism. forced drugging. And there, the US Supreme Court hasn't explicitly held, but it's pretty clear that they have to prove by clear and convincing evidence that the forced drugging is in the person's best interest, and there's no less intrusive alternative. And really, I'm sorry, I should have mentioned on the commitment too, that they have to prove that there's no less restrictive alternative for commitment. And for forced drugging, that there's no less intrusive alternative that would meet the the objectives of the state. And for forced drugging, basically, when you look at the evidence, there's just no way that you can prove either that it's in the person's best interest by clear and convincing evidence, or that there's no less intrusive alternative by clear and convincing evidence, because we know that the drugs actually do far more harm than good, and that they're proven alternatives. I could talk about that a little bit, the proven alternatives.
Yeah, so why don't you tell me a little bit about what, especially my particular interest is in proven alternatives that once presented to a court have actually been agreed upon by a judge and maybe even has kind of ruled in favor of those alternatives.
Well, that's a little bit harder. Alternatives that have been proven to a judge. I've got a case in the Alaska Supreme Court right now on the less restrictive alternative. And it was that we had this program called Soteria Alaska, which was based on the study that Dr. Loren Mosier did in the 1970s. He was the chief of schizophrenia research at the National Institute of Mental Health, which basically showed that they could get 80% of the people presenting with first-time psychosis through their episodes and onto their lives without the use of drugs, or very minimal use of drugs. And Soteria Alaska was based on that, but we had a hard time, or they had a really hard time getting first-time people. But still, it was a very effective program, but it had closed the year before due to insufficient funding. And one of the things, and so our argument was that you can't close a program that's a less intrusive alternative and then say there's no less intrusive alternative, because it's a constitutional requirement. It's basically a restriction on the government's right to lock someone up. If something's what's called a fundamental constitutional right, the state has to show a compelling interest, which in this case is safety, public safety, and it has to do so in the remedy has to be narrowly tailored, is what they say, to meet the objective. And there can't be any, like I say, less restrictive alternatives. And you can't just, like I say, not fund a program and then say it's not available. I have to say that the Supreme Court, Alaska Supreme Court, was not very receptive to that idea. They got pretty hung up on the idea, oh, you're saying that if someone is dangerous and there's some theoretical program, but it's not really there, that we have to let the person go. So I'm not actually that optimistic about that case. So there really haven't been a lot of cases that have actually held that, and that's the basic reason why I talk about these types of proceedings as basically kangaroo courts or shams, because they have all these legal pronouncements of people's rights, but they're pretty much not honored. In fact, I wrote a law review article called Involuntary Commitment and Forced Drugging in the Trial Courts, Rights Violations as a Matter of Course. So it's just pretend. The Supreme Court in the 70s, and the U.S. Supreme Court in, I think, the 70s started saying, well, people need, you can't just lock people up based on a psychiatrist or two psychiatrists' signature. People have due process rights. So then they set up these phony baloney proceedings.
Okay. Let me ask you this. I've read that there are kind of two different conditions, or not, I won't say conditions, but two different metrics, I guess, that have been used. One based on competency and one based on dangerousness. And I got a little confused when I was reading about it. It sounded like one used to be used, now another one isn't. And then it seems like different states have different policies. So how does like competency and dangerousness come into play?
So the dangerousness, you have to look at, that principle of a compelling state interest, and what is a compelling state interest. So for commitment, it's the danger. For forced drugging, it's the basic rationale. I mean, everybody has the absolute right to decide, what goes in their body, what drugs to take, if any, except if they're not competent to decide. And so then what the state says, it's called the parens patriae doctrine, which is their justification, which is basically this person can't make decisions on their own, so we're going to act like their parent and make the decisions for them. And so basically, before you even get to whether or not it's in the person's best interest, there has to be a finding that the person is incompetent. So that was a very good question. Maybe interestingly, in the Myers case, which was Faith Myers versus the Alaska Psychiatric Institute, which was my first case, I took the deposition of the psychiatrist, and he basically testified at the deposition that if the patient agreed with him, he decided to take the drugs, he would say they're competent. And if the patient disagreed and didn't want to take the drugs, he decided that they were incompetent. And the really sad thing was that the judge didn't care and went ahead and said that Faith was incompetent. And the transcript is actually on the psychrights.org website. And I defy anybody to say that she wasn't competent if they would read her testimony.
Was the claim something like, what do they call it? I can never pronounce the damn word. If you can pronounce it, it should be an indicator that, anosognosia.
Anosognosia. Yeah, you kind of drove it out of my tongue, but yeah, anosognosia. Just like I've learned how to say phenothiazine, which is the old style neuroleptic, like Thorazine.
Now, was anosognia, was this condition, was that kind of used against her, and has that typically been a valid claim that courts use as you have insight into your illness?
Anosognosia is actually a neurological condition, which is if someone has sometimes a serious brain injury, and they first noticed this, I think, in World War I, and people had, pieces of their brains blown away, that they didn't know that they were impaired by because of the brain damage, and that's anosognosia. So psychiatry has hijacked that, and basically to say, so that if anybody disputes that they're mentally ill, then that's anosognosia. In other words, if you dispute that you're mentally ill, that's a symptom of your mental illness. Just like so many things, anything that you do is a symptom of your mental illness. And so it's really very circular.
Okay, so what would you say are the main issues with involuntary treatment, or as you're calling it, I think, psychiatric imprisonment? But aside from the fact that it seems unethical and we don't like it, I'm more interested in, in terms of effectiveness, I guess. What kind of issues come up with use of involuntary treatment?
Well, I think, and then there's a third type I was going to mention, which is community drugging orders, which is euphemistically called outpatient commitment or New York assisted outpatient treatment. Um, and that's basically where people are ordered to take drugs in, even when they're out of the hospital. And that's even more of a sham. The highest court in New York, it's not called the Supreme Court in New York, it's called the Court of Appeals. They held that these weren't even forced drugging orders, because all they did, if you didn't take the drugs, then that would just cause heightened scrutiny, and the person could be put back in the hospital. So I'm sorry for getting away. What was your question again?
So what are the main problems when it comes to
Okay.
involuntary treatment, the negative effects of it?
Okay, well, I think you've got to look at the two things separately. There's been a lot of studies that show that involuntary commitment or psychiatric imprisonment is very harmful. It's more traumatic often, and people say that the experience of being locked up was worse than whatever problem it was that brought them in. And in fact, people that have been psychiatrically imprisoned are far more likely to commit suicide. It's so traumatic that people commit suicide as a result of it. And it's not really treatment. It's how can you say that confinement is treatment? In fact, when you look at the definition of inmate, it says someone confined to a prison or hospital. So people that have been, that's why I say psychiatric imprisonment, but people that have been involuntarily committed are inmates. But you really then have to look at what do they do in the hospitals, and they basically, pretty much the only thing they do is prescribe drugs or give people drugs, whether they want them or not. And the drugs have been shown to be very counterproductive and harmful. I mean, I would argue that the psychiatric drugs reduce the recovery rate from a possible 80% to 5%. I mean, that's really, pretty striking. And the way that I get that is if you look at the original Soteria study, and if you look at the open dialogue approach in Finland, both of them achieved about an 80% recovery rate with no or minimal drug use. And that's people coming in with psychosis. In Soteria's case, it was all people diagnosed with schizophrenia. And they would help people through whatever they were going through. They would, they would say, the process is to be with people rather than to do to them. And they got an 80% recovery rate. And the same thing with the open dialogue approach, where they basically say, the problem isn't really in the person, that's got the psychosis or whatever. It's in the spaces between the people. In other words, it's in the relationships, and they bring in the family and workers and schoolmates and all that kind of thing. And the person is never excluded. And they achieved an 80% recovery rate as well. And most of those, almost all of them had not been put on neuroleptics or just a very small amount for a short period of time. Okay, then there was a study by Job and Harrow, a naturalistic 15-year study. And what they found is that people who had been put on the drugs, who had been on the drugs for a while, if they got off the drugs, there was a 40% recovery rate. Okay, but if they stayed on the drugs, there was a 5% recovery rate. Okay, so what that tells me is that it's just hugely important to do as much as possible to avoid putting people on the neuroleptics as possible. Because once you're put on the neuroleptics for any length of time, your chances of recovery, even after getting off of them, go down from 80% to 40%. And then if you stay on them, you have a very low chance of really recovering and getting back to a high functioning level. Now, I will say, I do know people that take them voluntarily and feel that they're helpful. And those are the, I think that people should have the right to take them if they find them helpful. But if people don't want to take them, they're not going to be helpful to them. And it's probably that those are the people in the 5%. And a lot of people will take them, just periodically when they run, when they're having trouble, then they might take them.
Sure. Now, I know that you're based in Alaska. Can you tell me a little bit about kind of the variations in the laws across the different states and even from country to country? Are certain places more restrictive, less restrictive, and what kind of conditions or environments in those states kind of result in having more or less lax laws regarding involuntary treatment or
I think
psychiatric imprisonment?
It's kind of variations on horrific. So in Alaska, for example, the hospital only has 80 beds, although now they're kind of authorizing some others in some private hospitals in different cities. So the result of that is that people aren't locked up as a rule that long. But of course, they try and track them into situations where they're forced to take the drugs, even if they're not under court order. In other places, people tend to be locked up for a very long time. I think New York is one, California can be one. I'm not so sure about California. Texas, and then there's no forced electroshock actually going on in Alaska anymore, but there is forced electroshock going on in New York and Texas and California, Virginia, many other states. Minnesota's Mind Freedom had this big public effort to help. I forget his name, in Minnesota, who was being electroshocked every few weeks, and managed to get it stopped for him. But of course, there's thousands and thousands of people being electroshocked against their will around the country.
Great. Now you mentioned assisted outpatient. Actually, let me ask one more question. So what does the process look like for somebody being treated involuntarily? Do they get a due process? Is it, what is it? Is it shoot first, ask questions later? Like what is the actual process? And I know it changes from state to state, but can you give it a general idea of the process?
It's pretty, the basic process is pretty similar, which is there's a summary, kind of very expedited process for getting someone brought in to be, quote, evaluated. And so lots in Alaska, for example, any physician and any police officer can just make that happen. In Alaska, they've only got 48 hours. They can only lock them up for 48 hours without then filing a formal petition for involuntary commitment, which then has to be held within 72 hours. And they don't count weekends and holidays, although they probably should. Other states, people can be held up to 7 to 10 days in this evaluation phase. Okay, then you don't really have an attorney in the evaluation phase normally, but you normally then have an attorney appointed for you for the involuntary commitment phase, which you know, in Alaska, there are public defenders, or, you know, the phrase is public pretenders. And the basic, from my perspective, there's some real problems. I mean, in Alaska, the public defenders usually get the cases for that day, for any particular day that they're going to have a court hearing, that morning. So that, you know, you can't pause, and then they might get 5 cases and be just one public defender. 5 cases that are supposed to be, you know, disposed of between 1:30 and 4:30 that day. So there's no way that you can adequately represent someone under those conditions. Excuse me. So when I was taking these cases, I would always tell my potential client, you know, I can't do it today. If you want me to take your case, I got to have at least a day, maybe a couple days, to try and put a case together. And if you don't want to wait, you can have the public defender and almost certainly lose. And if you decide to take me, you at least have a chance of winning. So from my perspective, it's, you know, it's really a checkbox thing, which is, did the person have a, you know, legal hearing? Check that box. Did the person have a lawyer? Check that box, even though neither of those processes are really legitimate. So in Alaska, after you've been committed, then then you can be subjected to a forced drugging proceeding. And they tend to, the public defenders and the state, they tend to do them together, but they're not supposed to be together. And I will always try and separate them. And the Alaska Supreme Court has basically said they should be separated. I mean, so the idea with having to have a hearing within 72 hours of filing a commitment petition is that, you know, this person is being locked up and their very important right to liberty is being infringed, and therefore it's important for them to have, you know, a judicial determination as soon as possible. So in Alaska, for example, you can only ask for up to a week delay in that, with the concern being that the lawyers would keep asking for delays and people would be locked up for, you know, maybe fairly lengthy times without ever getting a court hearing. So that's, I think, a pretty legitimate thing. But you shouldn't have them so fast that you can't put a case together. Now, in these hearings, obviously, when the public defenders take these cases, they haven't arranged for any witnesses to come. They haven't done any investigation. They may have talked to their client for 5 minutes, maybe more, but not much more. The hospital comes in with a psychiatrist, you know, and they're in Alaska, and I think most places, the hearings are actually conducted in the hospital. Some places have actual courtrooms. In Alaska, it's this little kind of conference room, so it doesn't even look like a courtroom. So you have the psychiatrist, and then the only other, or maybe some other people at the hospital that are against the patient, and then you've got the patient whose credibility is automatically shot because they've been labeled as crazy. And so it's a very steep hill to climb under those circumstances, and not a fair one. So on the forced drugging, you know, it's basically similar. The idea, though, in the Myers case too, the Alaska Supreme Court said, look, in commitment, a person's rights are being infringed because they're locked up, but in forced drugging, you're actually trying to get an order to infringe on someone's rights by getting a forced drugging order So it's not so important that it take place so soon, although they do say that the state has a pretty big interest in drugging the person as soon as possible. So I don't know if I've answered your question or not.
Yeah, definitely. It seems, I guess it makes sense. There's kind of separate processes for locking somebody up, and then a separate process to force medication on them.
Right.
Now, we talked briefly about assisted outpatient treatment or community-based forced drugging.
I'd call them community drugging orders, but nobody else does.
So let me ask you this: now, people that are undergoing a community-based drugging order, are these people that would have normally been locked up, and now the court is looking at it and saying, "Hey, we could have locked you up and forced you on drugs, but we're letting you out in your community"? Or are these people that normally would have been out in the community and been free, and now they're being put on drugs? Like, what, the people that land in that niche?
There's what the legal pretensions are and what actually happens. So the legal pretension is that, yes, this is someone, it has to be in New York anyway, which I'm most familiar with, but I think most of the states that are modeled after this, it's someone who has been locked up and found to be dangerous. And in order to let the person out, they're subjected to this forced drugging order. And that then if they don't take the drugs, then you have the threat. They're saying, well, this isn't a forced drugging order, but if you don't take the drugs, we can call you back in and put you back into the hospital, lock you back up in the hospital. And that's why the New York Court of Appeals said that it's not really a forced drugging order. But I think the reality is that this allows them to have many, many more people, under a court order, because they don't have to, lock them up, have the expense and have all the room to lock people up. So I think it's a big expansion of, court control over people. And the whole idea with the forced drugging is that these people have been shown to be dangerous, and that's just simply not the case in most circumstances. And again, it's another example of where this legal pretense.
So let me ask this: how would you advise somebody to best advocate for themselves that's going through involuntary treatment or psychiatric imprisonment?
Well, I hear about people that, do that successfully. But my view is that it's really hard when have been labeled crazy by, a supposed expert to come in your own defense. And I personally feel it's really good to have someone else come in and advocate on your behalf. As being the best thing. Now, PsychRights has published, it's on its website, this forced drugging defense package, which is pretty old right now, which has some legal arguments and a couple of affidavits about why, forced drugging isn't in a person's best interest. And so a lot of people, I think, have used that. It's unclear to me, how successful people have been with it. Again, I think it's best to have someone else that really advocates for you. And most states have what they call advanced directives or mental health advanced directives, where when you ahead of time say, and presumably competent, and my recommendation is to get a psychologist or psychiatrist to actually sign and say you were competent when you filled out this advanced directive saying, whatever your wishes are, I don't want psychiatric drugs. Because the legal pretense, the legal justification for drugging someone against their will is that the person is incompetent to decline the drugs. And so if you have this formal expression of desire not to take the drugs while you are competent, then they shouldn't be allowed to do it. I don't say that that's a surefire way to win, but it's certainly a good thing to have. And one of the things that they have is most often, or at least one of the options, is to appoint someone to make decisions for you in this regard if you've been declared to be incapable of making your own decisions. So from a legal perspective, that should be pretty powerful. In practice, it's not nearly as powerful as it should be.
So is that one of the questions I was going to ask is about power of attorney and guardianship, and I was curious what the difference is between these two things and if they're the same. And I guess my other question is, you said in practice it's not very effective. So
well, I don't know how effective. I think it really depends how vigorously it's been asserted as to, how effective it is. So a power of attorney is basically where the person designates someone to make their decisions for them. Now, sometimes you say that power of attorney remains in place if I've been declared to be incompetent, and sometimes not. In this case, obviously, you should say yes. And one of the things is once all this stuff has to be done in advance, because once you've been, there's been a question raised, or you've been especially declared to be incompetent, then you're not in a position to, legally make these decisions. Now, guardianship is something completely different usually, which is where someone comes in, usually the state, and says that you're incompetent to handle your affairs, your own business, and therefore we need to appoint someone to make decisions for you. There can be limited guardianships or full guardianships, but the basic idea is that once a guardian is appointed or a guardianship created, then you now have the legal status of a child. It's called you're the ward, and the guardian has the right to make all your decisions for you. So I'm pretty against guardianships, as you can imagine. They're very grossly overused and abused in Alaska. Susan Musante, who ran Soteria, Alaska, and has a lot of experience in other places, says she's never seen them abused as much as they are here, but I've seen them abused in other places as well. Sometimes parents feel, if I don't get a guardianship, then, they're going to do all this stuff to my child. And it's a pretty tough situation. I feel like it's just a bad relationship to, for a parent to have over an adult, child, if that's not a contradiction in terms. To have that set up I think it's just really bad for relationships, but sometimes, situations are such that maybe it's warranted. I tend not to be in favor of them. I mean, the other side of it is that lots of times the state or someone will move for a guardianship, and if the parent isn't appointed the guardian, then they'll have the public guardian appointed, and they're pretty indifferent and generally terrible. Some places, then if there's a guardian, like I think in Arizona, which I'm somewhat involved in a situation there, if there's a guardian appointed, then if the guardian gets to consent to the drugging, and so then it's considered voluntary, even if the patient doesn't want it. and in this case I'm kind of involved in Arizona, the parent as a guardian, doesn't want her child, her son, drugged, and so they're trying to get the state, her removed as a guardian, and the state appointed as a guardian, because she won't agree to have her son drugged. So it's all a pretty pervasive abuse of power by the government.
So how should a friend or a family member advocate for somebody, if they have a loved one that's undergoing, forced treatment, forced imprisonment?
Well, I think the best thing is to really try and avoid getting the person where they've drawn the attention of the authorities. So people need a safe place to feel safe, and just to be able to go through what they're going through. And if that can be arranged, I think that's really best. There's a psychologist in Northern California, Michael Cornwall. He's a blogger on madinamerica.com, and he talks about I think he's in his 60s now, maybe 70s. When he was a young man and he was basically crazy, his grandmother let him stay in her basement, and he was there for, I don't know, it may have been as long as a year, I think, for him to kind of get through everything. And so I think that's probably the best way. Once you get caught up in the system, it's very hard. So you really, it's best to avoid it if possible. And, if you get caught up in the system, if you can hire a lawyer who will be aggressive, that's good. One of the problems is hardly any lawyers know anything about this area of law. I mean, it's actually very few people that have the money to pay for a lawyer. Lawyers are ridiculously expensive. My rate is $325 an hour, and that's, I think, considered pretty low. So the only people that really know this area of law very much are the attorneys that work for the hospital, and the public defenders are the publicly appointed ones. And they tend to not put up much of a defense. I mean, I always file motions, I'll file what's called a motion to dismiss, saying even if what they allege in the petition is true, they don't have the right to lock my client up. And those kind of things, and just make a big deal. I mean, I mentioned I took a deposition of someone, of a psychiatrist, and I've done it a number of times. Before I did that, I don't think they'd ever taken a deposition of anyone. They just go into they just go in cold into the hearing with no preparation at all. I think I've gone a little bit afield from your question, which was, what do you recommend?
Actually, so you had said basically avoid the system. So what about people that are they're already in? We've passed that point.
Right. And I think you got to try and get an attorney who will really work for you. It's really important to get quote an expert witness on your side. And I would say I think that there's a pretty good argument to be made that if you get caught up in the system, just cooperate, and that's going to get you out sooner, and then deal with the aftermath after you get out.
There's a part of me that wishes
that's probably not the answer that you're looking for, but realistically, if you don't have, an aggressive attorney that's going to help you, which you almost certainly won't, the deck is so stacked against you, and once you resist, then basically the system is designed to break you, and so just go along. I mean, one of the problems is everything that you do in the hospital is considered a symptom. So if they, if they lie to you, for example, which they do all the time, and you get upset about it, then you're labeled as agitated, right? If something absurd is going on or whatever, and you kind of laugh to yourself, then you're responding to internal stimuli, right? And then if you say, okay, I'm just going to be calm and I'm not going to react no matter what the provocation, then they'll say that you have a flat affect. So it's really, it's a really tough situation. So I think unless you, again, have, some strong resources behind you, maybe the best thing is just to do what they want. Take the drugs. Maybe you can negotiate it down a little bit. Take the drugs, hopefully for a short enough time to get out, and then deal with it.
Yeah, it's not necessarily the answer I wanted to hear, but it's the answer that everybody gives. Is just do what they say to get out, and then fight your battle. And it seems like that's
now Faith. I told Faith that, but she really wanted to fight, and so I did. I went to war for her, and won a pretty important Alaska Supreme Court decision as a result.
Now, speaking of court cases, can you kind of give me the a timeline of maybe the key cases in the history of the psych survivor movement?
Oh God, I'm terrible with case names. So in the 1980s, basically, there got to be, it was kind of in maybe the 70s, even the aftermath of the civil rights movement, got to be this idea that people had some due process rights, and they weren't allowed this, they shouldn't be allowed to be locked up just because a psychiatrist signs a piece of paper. So then, there got to be, some cases go to the U.S. work their way through the courts to the U.S. Supreme Court, and basically the U.S. Supreme Court said that you have to have, the people have the right to a judicial process, right to an attorney, and that a person can only be locked up if they're mentally ill and a danger to self or others, that being so incapable of taking care of oneself that without the help of others, they're unable to survive safely in freedom. That's what become known as kind of the gravely disabled standard. That was all right. They also said that you had to have proper procedures and evidentiary procedures and evidentiary standards. So that's one of the areas that I've pushed back on. And so that includes, being told what you're charged with, the right to present your own witnesses and cross-examine, and have a neutral decision maker. So then there's never really been, there's this case, I used to know all these cases, but there was this case involving a severely developmentally disabled person, and they were living in just really horrid conditions. They were in like this institution, not getting any therapy or help with becoming more self-sufficient and all that kind of stuff. And all of the so a case was brought against the institution for that, saying that a person has the right to some treatment, if they're being locked up, to achieve as high a level of functioning as possible. And all of the professionals were saying they weren't doing, that this person wasn't getting that sort of help. And so then the Supreme Court said, well, you have to provide services up to, what a professional, what was the word they used? Professional standard. It's not exactly the way that they phrased it. So then that got turned on its, and basically that was a case to get more, help for people to get a person out of really horrific conditions, and that got flipped on its head, so that so then it became, especially for people diagnosed with mental illness, that the standard was the professional opinion, so that you had to that the state had the right to force treatment on a person like drugging if it was up to professional standards, and I think that's fundamentally wrong. And then there was this case in I think the mid-2000s, United States versus Cell, which was about, it was actually about Medicaid fraud. I mean, it was a criminal case against a dentist for Medicaid fraud, and he was said to be mentally ill, and they wanted to drug him to make him competent to stand trial. And the US Supreme Court said, well, in order to do that, you have to have a compelling state interest. The forced drugging has to be in the person's best interest, according to medical standards. In the person's best interest, there has to be no less intrusive alternative, and the forced drugging has to achieve the results that that they're seeking. And so that was actually pretty important. It was in the criminal drug someone to make them competent to stand trial and context. But I think that really indicated that the Supreme Court that basically held these were people's fundamental rights. And one of the things is that, is it achieving the government's objective? Well, I remember, I forget the guy's name who shot Gabby Giffords. Remember, he killed a number of people in Arizona, and then he was charged with murder and assault and all that, attempted murder. And they said he was, crazy, incompetent to stand trial. And he would be in there, and he was very disruptive in the courtroom and all that. And so at first, the Ninth Circuit wouldn't let him be drugged against his will. They said, you didn't follow the cell standard, and sent him back. And finally, they allowed him to be drugged against his will. And they said, oh, it really worked. He was able to, sit in this courtroom for 7 hours and hardly, raise a peep. Well, obviously, he was so, drugged up. He was in a stupor. And so that's their idea of achieving the objectives of the state, is that they make so that the person's not causing, a commotion or anything. Where the standard for being competent to stand trial is only, are you capable of understanding the nature of the charges against you, and are you capable of assisting your lawyer? But that's not truly what it's about.
Yeah. Okay. Now, what about, I've read a lot of cases where people have filed suits against pharmaceutical companies, and there's been massive settlements. I mean, some in order of billions, multiple billions of dollars, and quite a few in the hundreds of millions of dollars. So how do cases like those get started? And are there a lot more of those cases that we don't hear about that get settled out of court versus the ones that actually appear in court?
Well, so people think that the one that I'm most often associated with is the Zyprexa case, where Zyprexa causes, or olanzapine causes, massive diabetes, massive amounts of diabetes, other metabolic problems, weight gain, huge amounts of weight gain. Even people don't get diabetes, on the order of 100 pounds or more. And there was like I don't know, pretty close to 60,000 cases filed against Eli Lilly about that. And those cases were consolidated into one court case, one federal court in the Eastern District of New York for discovery and settlement purposes. And so discovery is where you have the right to information from, the parties have the right to get information from each other. And the idea is, geez, you have 50,000 cases, 60,000 cases. Let's all pool all that discovery together. And that way you don't have to, have separate discovery skirmishes in 60,000 cases. And then, maybe negotiate settlements. Well, in Zyprexa, there was a first settlement reached, I don't know, I think maybe in 2005 or something, for some 25,000 people, where they got, I think, 60,000, each person got $60,000. And these were people that got diabetes. It's not a class action. People think it's a class action, but it's not. But in any event, so then out of that, the lawyers take, I think 40% in this case. They used to just take a third. Now it tends to be 40%. And then Medicaid took a certain, maybe 30%. And then if people are on SSDI, or I guess SSDI, then, there's an asset limit, and they have to, they can't have that much money or they'll lose their benefits. So from my perspective, these weren't very beneficial to the victims. They're very beneficial to the lawyers that represented them, because, you get a few thousand cases with, where your fee is $20,000, that adds up. It was very beneficial to the pharmaceutical company because it caps their liability. So, for example, Zyprexa, I think you could say it was probably, if you add up the civil settlements, from the victims, and then the settlement with the government for violating Medicaid and promoting off-label uses and criminal penalties, that was maybe they paid maybe pretty close to $5 billion. Well, at that time they were selling $5 billion worth of Zyprexa a year. So it was just a cost of doing business. Now, the whole basis for those lawsuits are that the drug company didn't tell the doctors about the risks or harms of the drug, in this case, Zyprexa. Well, that's got a statute of limitation on it. And so there's not really the chance of bringing more lawsuits against Lilly. One of the, I think, interesting things is that after Lilly was exposed on this, which is what I did, that a lot of states sued Lilly for the extra costs of treating patients, on Medicaid for diabetes caused by Zyprexa, and then they turn around and force people to take Zyprexa, in these other court cases.
So you say you were involved in that. So basically you had the state going to them and saying it's wrong that you put kids on these drugs, and we're suing, Eli Lilly for it. And then the state turned around, forced people to take these drugs. And so where did you come into play in this?
Well, I had been contacted by an expert witness in that case, and he said, I have these secret documents that show that Eli Lilly hid all this stuff and was illegally marketing the drug. And if you subpoena me, then I have to give Lilly notice and a reasonable opportunity to object. And if they don't object in a reasonable time, I'll give them to you. And by the way, there's a reporter at the New York Times who's interested in this, and why don't you get them to him? Which we did all that. I mean, I'm actually writing a book right now about it. And so the New York Times had like 5 or 6 straight days of coverage on this, the first 2 on the front page. So it was a pretty big deal at the time. And so that's how this information about Lilly hiding that they knew it caused diabetes and that they were illegally marketing Zyprexa to children and seniors came to light.
Now, have they come after you in any way? Here you're kind of this renegade lawyer who's going after the big boys. Have there been consequences for standing up to them in this way?
Well, oh yeah, they came after me really, really hard, so there's a big trial in New York. I ended up with, I think, $300,000 in attorney's fees, that I incurred, 100,000 of which I've never been able to pay. I was enjoined from this. Of course, early on I was ordered to return them, but I'd already gotten them out to the New York Times and a bunch of other people. And I was ordered not to further disseminate them and permanently. And the judge held that I had conspired to steal these documents.
So those are like criminal charges then, that they came for being, I guess, like a whistleblower or a leaker of some kind?
Lilly threatened me with contempt charges, criminal as well as civil contempt charges, but they never actually filed them. One of the things that happened was when I got this call from this expert, Dr. David Eagleman, I can't just subpoena something. I have to have a case. So I went looking for a case, which in itself was pretty hard because these cases are all confidential, secret. So that's a whole other story. But when I found this guy, and he was being forcibly drugged, and I thought it was probably Zyprexa because it was very popular at the time. And I asked the hospital to give him a consent for release of information to sign, and they wouldn't do it. And they said, well, he's got a guardian, and only the guardian can, sign a release of information. So by the time I had been hauled into court on this, I couldn't testify that he had been given Zyprexa, which they jumped all over in the court. All over. Well, it turned out that he had been forcibly drugged with Zyprexa within a month, before, I had the subpoenas issued, and a month afterwards he was as well. But that was, I didn't know it at the time of the trial. And then when I appealed it to this Second Circuit Court of Appeals, they wouldn't even consider that because it wasn't in the record.
Wow.
You look confused.
No, this is like its own little thriller movie.
Well, I think it's pretty interesting, and I am writing a book on it, and so I'm fairly far along on it.
Cool. So another thing I want to ask about was the Medicaid Fraud initiative. Can you give me a little detail on what went on in that case?
Well, it was this whole. Well, let me say first about what the idea of it is. Okay, under the Federal False Claims Act, if someone makes a false claim or causes someone to make a false claim, which means submitting something in for payment of money, and it really shouldn't. It's not right. It's not a correct request for payment. Then that's a false claim. And anybody in the country can sue on behalf of the government for that. And this law actually, the first was enacted during the Civil War when unscrupulous munitions manufacturers were selling the government all kinds of defective guns and things that would explode and soldiers' faces and those hands and that kind of thing. And so it basically deputizes everybody to look out for fraud against the government. You can sue and get a share of that between 25 and 30%, basically, depending. And each false claim carries a minimum penalty of $5,500. Okay. Now, under Medicaid, Medicaid is only allowed to pay for drugs for what's called a medically accepted indication, which is what you mentioned in the introduction, and that's defined as a use approved by the FDA or supported by one of 3 drug references called compendia. Okay, so breaking that down, if a use isn't approved, then it's off-label. And people are kind of familiar with the term off-label. And so Congress didn't say that we won't pay for any off-label drugs or prescriptions, but we'll only pay for off-label prescriptions if they have scientific support as documented in these compendia. And so the idea of this was that is to sue the psychiatrist or other prescriber for causing a false claim when they write a prescription that's not for a medically accepted indication. And in the case of pediatric psychotropics, I mean, there's kind of rampant off-label prescribing anyway, because in the US, while the drugs might be approved for pretty narrow uses, once it's been approved for anything, doctors are allowed to prescribe it for anything. So then the drug companies get the doctors to prescribe it for other things, even though they're technically not allowed to promote it for off-label uses, but they're not, but the doctors aren't prohibited from prescribing. So there are all kinds of games that go through to do that. But anyway, that's a little bit afield. So the idea was that if you sue one of these psychiatrists or pediatricians or something for this off-label prescribing to children, that any psychiatrist worth their salt would have prescribed at least 1,000 of these in the 6-year statute of limitations. Well, that's $5.5 million. And the idea is that if we could tag one of these prescribers with such a judgment, that it would scare the other doctors into stopping what they're doing. And the Seventh Circuit basically agreed with us that when a doctor writes a prescription that's to a Medicaid patient that's not for medically accepted indication, they're causing a false claim. But then when we got back to the trial court, we had this judge who was kind of, well, he was very hostile. And he said, he said I was incompetent and, and I wasn't going to come in and not to wave that Seventh Circuit opinion around down here in front of his court, and threatened me and the other lawyer with sanctions if we didn't dismiss the case, and threatened my client, Dr. Toby Watson, who's the person who brought the case on behalf of the government, with ruinous attorney's fees if he went forward. And so he decided, not to go forward with it. So we never really finished that up, but we have a very good precedent at the Seventh Circuit.
Wow. So the idea there is that an individual psychiatrist, every prescription they'd written would owe $5,000 to the government, or I guess to whoever files.
No, yeah, it is to the government.
Yeah.
The penalty for causing a false claim, $5,500, if it's not for medically accepted indication. And the doctors all think that because they have the legal right to prescribe it, that they're in the clear. But they don't have that if they prescribe it for something that's not for medically accepted indication, they're causing a false claim and subjecting themselves to liability for that.
Wow. So it seems like you've had quite a few successes along the way, and they certainly hit some roadblocks. I mean, the 80s and 90s, you had the big battle in Alaska over the land trust. And then there was the Faith Myers case that you mentioned in early 2000s. And then I read about the Bigley decision. And then you fought for funding for Soteria, Alaska. You've been involved in the Medicaid fraud initiative. So what can you tell me about moving forward? You know, what does the future look like? What are your kind of future goals and desires? And I've read a little bit about the transformation triangle. And so kind of what do you want to see happen next?
Well, for me personally, I'm 65 now, and actually, I did all this work for PsychRights, on a volunteer basis, which is called pro bono for a lawyer. And I had a source of income that pretty much has been dramatically reduced. So I've had to really back off of PsychRights, and we've made this little funding, not little, a funding proposal called Getting to the Next Level to, try and get some serious funding to get some more lawyers. I mean, there's only so much I can do by myself. So, and again, I'm, not getting any younger. So PsychRights itself is pretty much, on hold, I would say, at best. And so, I think that we're in this witch hunting, scapegoating atmosphere where people diagnosed with mental illness are the easy target for all this irrational, all this inexplicable gun violence that we have, the mass shootings, which I think there's a pretty good case to be made. Most, if not a very large majority of them really can be attributed to the psychiatric drugs, which are known to cause that kind of violence in a small number of people. And when you have millions of people being prescribed these drugs, even a small percentage ends up, having a big impact. I think, there are a lot of people work. I think the most important thing is to really try and educate the public, that what we're doing with the mental health system is very counterproductive, very harmful, is actually making people in society less safe rather than more safe, and that the answer is not, involuntary commitment and forced drugging, because both of those things, really make things worse. And the second most, and that will, encourage the availability of other approaches that, so many people in the psychiatric survivor community know about, such as open dialogue, soteria, peer respite, other similar, intentional peer support, those kind of things that, have really been shown to be so effective that that it would hopefully encourage the support of those type of programs. And to the extent that we can get those kind of programs going and show how successful they are, that will really also increase, public knowledge about that this way to go is much more better. The legal side of it is probably the least important, but the idea is that, for example, in the Bigley case, the Alaska Supreme Court said you either have to provide him with a less intrusive alternative to forced drugging or let him go, and that by really pressing that issue, that might force, the state to, really fund a less intrusive alternative, because they don't really want to just, let people go. So that's kind of almost the entire transformation triangle. I think, again, the most important thing is trying to making the public aware of the reality of what's going on. And that's why things like the protests of the American Psychiatric Association next month is, so important.
Great. So our time is almost up here. Is there anything else that you had wished I had asked you about that you would want to get out to the world that I should have been asking you about that you want to share?
No, I wish I'd been more articulate.
Oh, no, you're great. All right, cool. Well, let me ask you this. If people want more information about your work, where can they find that information?
Well, the best place is psychrights.org, psychrights.org, psychrights.org. We have a huge amount of information there. We're not really adding to it to the way that we have been, but still, I think it's a valuable resource.
All right, Jim. Well, thank you so much for doing this interview. I really appreciate your time.
You bet.